I put a question that the Uganda People's Defense Forces Amendment Bill 2025 be read a third time and do pass. Those in favor say the court.
Order, Madam Speaker.
The ayes have it.
The boycott by the opposition wing did not affect procedure as legislators progressed to debate the Uganda People's Defense Forces Amendment Bill 2025.
Title settled and the bill passed.
Order, Honorable Kasaija.
I am confirming to you that we did not participate in writing of the report. When we started writing the report on Monday, the chairperson informed us that they were summoned to go to State House. And they promised that when they come back from State House, we shall complete the report. And we did not see them. Until today, we are seeing them in the House.
Amid this tight security around the August House, legislators proceeded with the bill after days of political wrangling.
On the issues, stop merrymaking.
The chairperson of the Defense and Internal Affairs Committee of Parliament, Wilson Kajwenje, presented a report of the Joint Committee supporting, among others, the trial of civilians by the court-martial under exceptional circumstances. This cites that the trial needs to be fair.
This requires changes to the military court structure to ensure that those presiding over these trials have legal training and appointed through a transparent process, a function independently of their superiors' influence.
This provision, including the jurisdictions of the court-martial, are contentious elements the critics have raised.
The members of the UPDF court-martial must be independent and impartial. They told us how they believe the independence and impartiality should be set out. Taking of the oath, we put it in clause 45.
The report asserts how civilians wearing similar attires of the UPDF, including berets, may impersonate military personnel, hence compromising security coordination.
In light of the evolving security threat and expanding military responsibilities, there is a critical need to realign the UPDF structure.
It is also reported that the civilians can engage in actions which impact on national security.
The committee acknowledges that military laws apply to officers and personnel within the defense forces, but they also address elements of national security.
Despite their absence, two minority reports were presented. Kyoga County MP Moses Okot cautioned the House against making laws to overcome the decision of the Supreme Court. He wanted the General Court-Martial to remain a tribunal.
For instance, since terrorism can only be tried by High Court, which is an ordinary or civil court, it would be contradictory to try it in the military court as well.
The offenses provided in the bill: murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling have all been provided already in our law books. That is the Penal Code Act.
Lack of public participation is a concern that has not gone unnoticed as the bill was against time.
We had discussion with Office of the Director of Public Prosecutions. While processing this bill, Right Honorable Speaker and Honorable colleagues, we also entertained private legal practitioners. In this case, Counsel Jude Byamukama. We also entertained and granted audience to Kampala Reduction in Force veterans of the UPDF.
MP Jonathan Odu presented the second minority report, tagging the Attorney General Chirowa Chiwanuka of double standards on the execution of the Supreme Court declarations.
Right Honorable Speaker, the offenses provided in the bill: murder, aggravated robbery, kidnap with intent to murder, treason, misprision of treason, and cattle rustling have all been provided already in our law books. That is the Penal Code Act.
Yes, it is true, Right Honorable Speaker, that I did interpret the decision of the Supreme Court in the letter my learned friend Honorable Odu raised of 3rd February. And yes, I did state that our understanding of the Declaration 7, 8, and 9 of the court is that civilians could not be tried in the military courts. Right, Honorable Speaker, Honorable colleagues, the military courts that I was referring to are the ones that exist now. The ones that exist now.
Chiyo Wachwanuka also dismissed allegations of interference with the sub judice process which was raised by MP Jonathan Odo. The over 100 clauses bill restructures the UPDF by creating new services such as the SFC and reserve force to improve operational capacity. Further amendments were proposed during the committee stage, where some MPs continued to object the jurisdiction of the General Court Martial.
It would not be prudent for lawmakers to skip the hierarchy of courts from the court martial and put it at the same level of the High Court.
But we wanted to reconcile with the practicability of having 3 lawyers who are highly qualified, who have handled murder, rape, these capital offenses, and
at the last hour, the bill was passed.
Yes, we shall display everything on TV for the wider public to understand what we have passed.
Daniel Mugoya, Gloria Gutabinji, UBC News.
Clause 12.